Assalamu alaikum everybody. My name is Dr. Faria Iqbal, and on behalf of Pakistan Psychiatric Society and Department of Psychiatry and Behavioral Sciences, I welcome you all to this webinar, which is organized by Pakistan Psychiatric Society in collaboration with the Federal Judicial. Before I go on further, I would like you to please mute your mics, other than the person who is talking, because then there will be interference in between the things that you hear. So today's program, we have two speakers. One of them is Dr. Khurram Hafiz Khan. He's a consultant forensic psychiatrist, and he is currently practicing at the State Hospital, Carstairs, Scotland. He has experience in medical legal report writing in criminal and civil cases, and has expertise in diagnosis and treatment of the forensic cases. And currently his vision is to have a better forensic psychiatric approach in Pakistan as well, and to bridge the gap between law and psychiatry. Next up, our second speaker is Ms. Robin Meher. She is a capital defense lawyer, teacher, trainer, consultant. Her experiences includes direct representation of state and federal death sentence prisoners, and she has been teaching to lawyers from multiple countries. Next up, I would like to introduce Huma Chaktai Saiba. She is Director Programs and Coordination at Federal Judicial Academy, and she'll be taking over in a while, so to introduce the personnel from Federal Judicial Academy. Last but not the least, we'd like to also tell you about Professor Muhammad Iqbal Afridi, who is President Pakistan Psychiatric Society, Dean JPMC and Jinnah Sindh Medical University, Dean Psychiatric Faculty at CPSP. He'll be joining us in a moment. And this is my cue, so I'll be handing over it to Dr. Huma Chaktai for proceeding further.
Thank you very much, Dr. Faria. On behalf of Federal Judicial Academy, I welcome you all to this webinar. And I'm really grateful to Dr. Khurram Khan and Dr. Robin, and also to Dr. Iqbal Afridi, whose organization, this institute, is co-hosting this webinar. It is a very important issue, as we all know. We need to learn more about it, and the more we explore the issue, the more issues and challenges come forward, and that will help us inform policies and legislation. I would now like to request our Director General, Mr. Hayat Ali Shah, who is a retired district and sessions judge and has been key in transforming the judicial education mechanism in Pakistan, to kindly give his opening remarks before we start off this webinar series. This is the second one for the district and sessions judge, and incidentally it was the first one was also around the same topic, and our very competent key resource person was Dr. Tariq from Canada, and I think this is going to really work on well with this one. So, and that had also a very positive feedback, and I hope that it's going to work out very well. I would request Mr. Hayat Ali Shah Saab to kindly give his opening remarks.
Bismillahirrahmanirrahim. Dear participants, respected guest speakers, Dr. Khurram and Madam Robin, and of course Iqbal Afridi. It was desire of Honorable the Chief Justice of Pakistan and the Administration Committee, which is overlooking this, the federal activities of the Federal Judicial Academy, that is Honorable Justice Mushir Alam and Honorable Justice Umar Ata Bandial. They directed the Academy that because of the COVID situation, we should go on virtual trainings and virtual education. So Federal Judicial Academy has started that, and this is the third webinar. One was for the district and session judges. Again, of course, it was on the issue of the mental health. Second was for the additional session judges. That was on juvenile justice system, and the third one, again, it is law for mentally ill defendants as psychiatrists plea. Mentally ill people are the most vulnerable people of the society. They may commit an offense. Rather, they may do something wrong. We won't say that it was an offense. They may, and how to deal them, no laws give us the procedure and other things. And our judges, of course, know that how they have to deal an accused person of, or a person in conflict with law who is mentally sick or mentally ill. But the view of psychiatrist is always important. Judges have to know the forensics relating to the mentally ill people. They must know the various kinds of mental illnesses. And for that, when Dr. Khurram and before him Dr. Tariq, when they offered their services to this academy and when they said that they can help us in understanding the issue, and they can communicate with the honorable district and session judges and other judicial officers in time when the time comes. So we, without any hesitation, accepted their offer. And I am thankful to Dr. Khurram and his team. And of course, once again, I will not miss thanking again Dr. Tariq. I'm sure that whatever they will be sharing with the judicial officers and particularly district and session judges, who are the leaders of the district judiciary, that will be of great value for them, both academically and management-wise, that how they are to manage the mentally sick people who come in conflict with the law. So without taking much of your time, I welcome all of you, my dear friends, district and session judges. I welcome you, Dr. Khurram and Ma'am Robin, and of course, Iqbal Afridi. So thank you all, and that's all from my side.
Thank you very much, Honorable Director General Saab. I would now request Dr. Khurram Khan to kindly commence his presentation, because I know it's going to be very interesting, and I don't feel that we need to spend more time on intros. So Dr. Khurram and Ms. Robin, please commence your presentation.
Okay, thank you, and assalamu alaikum to everyone. बहुत बहुत शुक्रिया हयात साहब, हुमा चुगताई साहिबा, Dr. Faria. I wanted to start by telling you a little bit about a city which is very, very close to my heart. I was brought up in Hyderabad, and after my matriculation examination, my late father took me to Umar Court. Some of you who belong to the province of Sindh would know Umar Court and its touristic attractions and touristic reputation. And I loved that city. So I've got a hypothetical case which is based in Umar Court. So a little bit about Umar Court. You would know that it is known for Umar Court Fort, which was built in the 11th century by Rana Amar Singh. Umar Court Fort is also known for a folklore, a folk story about a beautiful girl called Marvi. So in the 15th century, the ruler of Umar Court at that time fell in love with Marvi and offered hand of marriage, but she refused. So he imprisoned her in this fort. And ever since, she is known as a symbol of courage and one's love and respect for one's homeland and one's soil. Umar Court also has a good population of our Hindu brothers and sisters, and it comprises of about 48%. And there is this mandar called Shiv Mandir. So what I want you to do is to think about, it's a hypothetical case, And I want you to imagine that there is this state counsel or a public prosecutor. He's been assigned a case of a gentleman called Mr. Sirichand, who's a Hindu gentleman. He has been charged with the terroristic threats. He has threatened to kill the president, but not the president of Pakistan, which would immediately make this case a matter for secret services. He has threatened to kill the president of this Shiv Mandir Management Committee in Umarkot. He has also changed his name to Abu Asha. His daughter's name is Asha, because he had learned that Muslim fathers call themselves by the name of their children. Never mind that a Muslim does not use the name of a daughter in this fashion. Until recently, Abu Asha worked as a lab assistant in a laboratory, in a blood laboratory, but he had left his job, stating that he had managed to get a handsome amount of money and wanted to spend time with his family. He does not have previous criminal charges. His wife actually sends you, the state counsel or the public prosecutor, his curriculum vitae, his CV, Pakistan, as possible. So I talked about the principles of Mental Health Act, and one of those principles was informal care, or least restrictive option. Everybody's right. The Constitution of Pakistan gives us that right. Article 4 and Article 9 of Constitution of Pakistan states that no action detrimental to the rights of liberty of a citizen shall be taken except in strict accordance of the law. Human Rights Act, the European Commission of Human Rights Act, Article 5 states that the state has an obligation to ensure that the right to liberty is protected. It states that deprivation of liberty will be lawful. So there are situations where you can breach somebody's right to freedom. Some of these conditions as outlined here are the prevention of spreading of infectious diseases, if the person is of unsound mind, an alcoholic, a drug addict, or a vagrant. But if you are going to breach somebody's right of liberty as protected by the Constitution of Pakistan, by the Human Rights Act, how fully satisfy your own conscience? I think somebody has raised their hands. So I don't know, Huma or Farah, if you want to allow them to speak just now, or because it is going to be an interactive session.
They can unmute their mics if they want to talk.
Yes, Tasneem Murtaza, please unmute your mic if you want to talk. You have raised your hand. Okay. So what I was talking about, that Constitution of Pakistan and the article of Human Rights Act, what is it that this is the Mental Health Act of Pakistan or Punjab or Sindh or Balochistan, which would allow you lawfully to breach someone's right of liberty. Now, as I said, that I'm not going to talk in detail about the Mental Health Act today. That is not in order to help the courts with issues such as insanity or criminal liability. So Section 10 is a section of Mental Health Act. Some persons who's mentally unwell and also found themselves on the wrong side of the law, to admit them in the hospital for admission purposes for 28 days. So you can breach their right of liberty within working within this legal framework for 28 days in order to struggle or suffer from a mental illness, and to assess if that mental illness is some shape or form connected to the offense which they have committed. But you can reach their right of liberty. More than that, and you will be acting against the law. Secondly is the Section 11 of the Mental Health Act, which allows you to admit a mentally unwell person for treatment, but for 6 months. So you can detain them in a locked environment for whole 6 months to assess, treat their mental illness, as well as dissect and explore the legal, psychiatric legal issues in regards to the offense which they have committed, so that you can inform the court. It has got a section 12, which allows an urgent admission for somebody just for 72 hours. It has got a section 13, which allows an emergency holding of someone for just 24 hours. And it has got section 19, which allows the removal of a mentally disordered or mentally unwell person found in a public place to a place of safety by the police for 72 hours. Now, the question is that how this Mental Health Act would perhaps work in real terms, in real life. So I have designed this procedure in order to elaborate this point and perhaps initiate further discussion. So what are these procedures involved to illness, just like a crime? So the first contact, let's think about it systematically. The first contact, now remember, Ali, there is a suspicion that Ali might have some mental health problems. And he comes in contact with the police. Now, Mental Health Act kicks in right from the start, because we want to make sure that his mental health needs are cared for as early as possible, and the legal issues are taken care of in the due diligence of the law. So the first thing is, as I was explaining, that there is this section 19 of Mental Health Act, which would allow the police to remove Ali from this public place or from the police station to a place of safety. Now, what are those places of safety? That is described in the Mental Health Act as well, and none of them is the hospital or a psychiatric ward. The other issue is that whenever police apprehend someone or going to charge them for an alleged crime, the first thing is that they interview the person. They ask that person a lot of questions to determine what is the matter in hand. So if Ali is mentally unwell or suspected to be mentally unwell, that basically means that he's not in full control of his mental capabilities. If he's not in full control of his mental capabilities, there is a good chance that he will not give the right answers to the police, or he will talk about something which will be used in the court of law against him during the process of trial. And that is a prejudice, that is a bias at that stage of the proceedings. So fitness to be interviewed by the police is very, very important. What is that fitness all about? We will talk about that in the next few slides. And again, the section 10 of the Mental Health Act would allow Ali or Abu Asha to be admitted into the hospital for 28 days for the assessment of their mental condition and exploration of the legal issues, or for the whole 6 months if he indeed suffer from a mental illness that needs to be treated and the issue needs to be explored. What is the connection of that mental illness with the crime they have committed or alleged to have committed? The next stage, when we go through the process, is obviously the pre-trial stage. So a number of things needs to be taken care of at pre-trial stage. Obviously, the first thing is the continuing assessment and treatment of that person's mental illness. If that person somehow managed to get through the stage of the police inquiry trial, and that person is standing in the court of law, and the judge says, well, June, July, and he's wearing 2 sweaters, and he thinks that it is December. He's like talking all sorts of craziness, crazy idea. I don't know what's going on. So the Mental Health Act provides you this framework to immediately lift that person and transfer him into the hospital in order to further explore his mental health and the legal issues. And the sections which can be used are section 10 and section 11 of the Mental Health Act. Similarly, if that person was not bailed after the police had arrested him, but was remanded, in fact, tell me, what do you understand now? and then satisfy himself, yes, Abu Asha or Ali does understand what the court proceedings are all about. And finally, does Abu Asha or Ali understand that in the court of law, it's an adversarial system. In the court of law, it is based on argument. People will be arguing with each other. Evidence will be given for, evidence will be given against. Does he understand that process? In as layman terms as possible, it is important to explain this point to the accused. And finally, very importantly, is Ali and Abu Asha able to actually speak to their lawyer meaningfully? Are they able to instruct their lawyer? Are they able to tell their lawyer, listen, I want you to consider a plea of guilty for me, or I want you to consider a plea of not guilty for me? Are they able to speak to their lawyer, understand the reasoning and the argument of their lawyer? If their lawyer is asking them to enter into the plea of not guilty, do they understand it, what it means? So these are the tests which we employ. So whenever I assess someone and the honorable courts ask me to provide a psychiatric opinion, asking me whether that person, the legislation I work in here, the Mental Health Care and Treatment Scotland Act 2003 has got a section in it, which is section 53F. And that 53F is about fitness for trial. So the judge expect me to produce a report outlining all these points. The lawyer instruct me to produce a psychiatric report or psychiatric examination of their client, and specifically ask me, Dr. Khan, can you please provide an opinion on section 53F of Criminal Procedures Scotland Act 1995 or Mental Health Act Scotland 2003? And what I think should happen in Pakistan, that whenever a public prosecutor or a state counsel or a lawyer or a judge is dealing with Abu Asha or is dealing with the case of Ali, they should instruct an assessment, a psychiatric assessment of Abu Asha and Ali, and they should ask the psychiatrist to comment on the relevant section of the Criminal Procedure Code, the fitness for trial, the section 469 of the Criminal Procedure Code. We will come back to it later on. I'm conscious that it's already nearly an hour that I'm talking. There are a few more slides before I hand over to Robin, but can I just pause here for a minute and two and just gauge if where we are at and if there are any questions or any comments. Huma, could I just hand over to you, please, to facilitate if there's room for any discussion, what we have discussed so far.
So, do we need to move on to, would Robin want to say anything, add to it, or how do you want to
Yeah, sure.
with
We can proceed further. I've got a few more things to talk about before Robin, but I just wanted to check if there are any questions or any comments at this stage.
अगर कोई सवालात हैं तो please raise your hands because Dr. Khurram ने मुझसे ये शर्त ली थी कि वो इंटरैक्टिव रखना चाहते हैं और वो मोनोलॉग में बिलीव नहीं करते. तो अगर कोई हमारे ऑनरेबल पार्टिसिपेंट्स में से कुछ सवालात इस मौके पे हैं तो उन्होंने एक ब्रेक दी है और प्लीज आप लोग अपने हैंड रेज कीजिए और फिर हम आपको अनम्यूट करेंगे.
जफर इकबाल नईम साहब ने अपना हाथ.
जफर इकबाल नईम साहब.
जी अस्सलाम वालेकुम.
वालेकुम सलाम.
Dr. Sahab, my question is that as per section 11 or 12 you just referred, the patient can be a lunatic, can be admitted in hospital up to 6 months.
Ji.
So what will be the situation if he does not get recovered within that 6 months?
Ji,
and
ji.
if he needs further time,
Ji.
so is there any provision by which that period can be extended?
Gigi, a very good question. Thank you very much for this question. And these are exactly the issues which we'll be discussing in our next webinar about Mental Health Act. But to answer your question, आपके सवाल का जवाब देने के लिए ये जो 6 महीने की आज़ादी सलब की है उसकी, इसको आप further 6 months के लिए extend कर सकते हैं, working within the law as per Mental Health Act. You can extend it for further 6 months. And then there are provisions to extend it further. एक और important point ज़फर साहब इसमें ये है कि throughout this detention of that person, उसकी जो ये सारा process है आज़ादी सलब करने का, throughout that process, there are safeguards in the system in terms of appealing against that detention. So वो mental health act के बारे में जब हम बात करेंगे तो हम ये बताएंगे कि किस तरीके से वो person खुद या उसके loved ones, his relatives can appeal against that detention, क्योंकि psychiatrists, anybody can go wrong. We can be wrong in our assessment. कभी कभी हम misdiagnose कर देते हैं लोगों को, कभी कभी हम diagnose करते हैं लेकिन जरूरत से ज्यादा सख्ती करते हुए उनकी आज़ादी सलब कर देते हैं, जबकि मेंटल हेल्थ एक्ट हमको ये कंपेल करता है कि जितना ज्यादा मुमकिन हो उनको ट्रीट करो कम्युनिटी में, उनकी आज़ादी को वायलेट किए बगैर. तो यस, the question to your answer is that it can be extendable for another 6 months and beyond.
Thank you.
If required.
Thank you.
Thank you. Any further questions? Otherwise, I'll move on.
Sir, we welcome Professor Dr. Iqbal Afridi. He has joined prior.
Thank you. Assalamu alaikum, Mufti sahab. Okay, so I think I'll just move on to the next slide, which is the criminal responsibility of a person of unsound mind. So we have already talked about the section 84 of PPC, which says that nothing, these are the words, nothing is, these are the words which judges need to judge against and need advice from the psychiatrist. So the wordings are that nothing is an offense which is done by a person who, at the time of doing it or doing the offense, by reason of unsoundness of mind, is incapable of knowing the nature. So the first test is the nature of the act, or that he's doing what is either wrong or contrary to the law. So that is the second point. So a judge should always be looking towards a psychiatrist to comment on the nature of the act, or that person understanding of the nature of the act, but also that person understanding what he was doing actually was wrong. That he could not appreciate or understand the wrongfulness of his conduct. So that is the test, and that is the legal and psychiatric connection between the two. And obviously we were talking about the acquittal on the grounds of insanity, which is described in 470 CRPC, that whenever any person is acquitted upon the grounds that at the time at which he's alleged to have committed an offense, he was, by reason of unsoundness of mind, incapable of knowing the nature of the act alleged as constituting the offense, or that it was wrong or contrary to the law, the finding shall state specifically whether he committed the act or not. Can I just invite Ms. Robin Maher at this point? And I think she's also going to touch upon some of the issues we've been talking about from a barrister's perspective. Over to you, Robin.
Hi, thank you, Dr. Khurram, and greetings from the United States to the honorable judges. I'm so pleased to be here with you today. Dr. Khurram has been talking about something that is so critical, so important, understanding the intent of a criminal defendant, the mental illness that sometimes disrupts the ability of an individual to understand the wrongfulness of their conduct. And so we talk a lot in the United States, certainly, and in other countries about mens rea, understanding that the act is not a crime unless the mind is guilty. And that means that there must be the requisite understanding of the wrongfulness of the crime and understanding the nature of the act. And again, the mental illness sometimes disrupts the goal of a society to punish appropriately and to deter conduct, to deter criminal conduct, because mental illness is going to interfere with an individual's understanding of the wrongfulness of the act, and will also prevent him from deterring himself, from being deterred by the threat of punishment. So in many, many ways, it's important that we focus on understanding what the true intent is here, and if there is mental illness, how that affects the intent of a criminal defendant. So there are many, many myths about mental illness, and certainly in the last few years, we have learned much more about mental illness than we ever have. In the last few years, we have understood the physical components of mental illness. We understand it now to be a mental illness, a physical illness, like many other physical illness. There is a chemical and physical component to mental illness. So many people believe that all individuals with mental illness behave strangely. They'll be behaving in a bizarre and strange way. But in reality, there are many kinds of mental illness, from mild to severe, and the symptoms will be different in everyone. And sometimes there are overlapping conditions, such as alcoholism or drug use, that disguise mental illness symptoms. For example, if an individual has schizophrenia and is hearing voices in his head, many people will try to self-medicate, will take alcohol and drugs to try to quiet those voices. So what may look superficially like a drug problem or an alcohol problem may in reality be a mental illness. Another myth is that people can fake mental illnesses and fool mental health experts. And the reality is that that is not possible when you have partnered with an experienced mental health professional, such as Dr. Khurram. Dr. Khurram and I share the belief that the law and psychiatry must partner in order to protect, as the Director General said, these terribly vulnerable people. And by utilizing experts such as Dr. Khurram, the law, lawyers and judges can understand better what mental illness is at work and how it has affected their criminal conduct.
Robin, sorry, can I just interject?
Yes,
Sorry to interject. I think one honorable judge has raised his hand. District Judge Kamber Shadat Court, Sindh. So Huma, could you please unmute Judge Sahab to speak?
कंबर शहजाद कोर्ट के जज साहब को मैंने अनम्यूट किया, प्लीज आप जो क्वेश्चन है प्लीज वो पूछिए.
Assalamu alaikum.
Mashallah.
Do you hear me, sir? Do you hear me, sir?
Yes,
Do
Robin
you
and I
hear
can
me?
hear you. Yes, Robin and I can hear you.
What would be the stage of the determination of the mental ill person? Would it be the trial, or would it be the investigation stage of the case, or would it be at the registration of the case?
Robin, do you want to take that question, or do you want me to?
Yeah, go ahead, Dr. Khurram.
Yes. So, Judge Sahab, as I was explaining earlier, that the process should start as early as possible. Can I just take you back to Siri Chand's case, Abu Asha's case? So remember, we really had some suspicions about his mental health. What usually happens is that the state counsel, whoever the lawyer is involved in, this is not a criticism. I'm just not talking about my Pakistani lawyers. I'm also talking about the lawyers where I work in this system. Most of them, not most of them, some of them. What actually happens is that in that Abu Asha's case, Siri Chand case, they will speak to Siri Chand. They will agree an agreement of guilty plea with Siri Chand. Siri Chand will agree that, yes, I caused a nuisance to the president of Shiv Manda. Siri Chand will also agree to pay some fine. And Siri Chand might attend some sort of counseling if that is available in Umar Court. And that is that. The desk is cleared and everybody will go home. But that should not be the case. As I was explaining earlier, that right from the start, so at the point of the police inquiry, even before the FIR is launched, the mental issue should be raised. And it should be questioned whether the police questioning of that person was lawful or not. The police caution, did he understand the police caution or not, as per the Mental Health Act? The other issue is the pre-trial stage. So the issue of the mental illness and the connection of that mental illness with the commissioning of the alleged offense is usually dissected and explored and explained at that time, the pre-trial stage, when the psychiatrists are involved and they are talking to the lawyers and they are deliberating on the issue of mental illness and its connection with the Section 84 of the Pakistan Penal Code. So the detailed inquiry actually happens at the time of the pre-trial stage. मैंने आपके सवाल का जवाब दिया है या अभी भी कुछ कंफ्यूजन मुझे बताइए जी जी okay, over to you, Robin.
Thank you. And so continuing, one of the mental illness myths that we hear a great deal is that mental illness is an excuse for criminal conduct, so that it is a way of getting away from any kind of punishment. But in actuality, mental illness is an explanation. It helps us understand what is happening in the mind of the criminal defendant, and it helps understand why someone may have committed some kind of criminal conduct, even though they are not aware of how wrong their conduct is. So it helps explain, but does not excuse conduct. And then the final myth I want to talk about is that the understanding that people with mental illness commit more crimes. This is a very common myth, but in reality, there's no evidence to suggest that they do commit more crimes. They often are convicted of crimes because they are unable to defend themselves, because there's no understanding of their true intent, but there's no evidence that mental illness is a reason for people to commit more crimes. If you can pull up the reality here, Dr. Khurram. Yeah.
Yes.
So it also makes it more likely they will be blamed or arrested, because in many cases, people with mental illness will be blamed by a more sophisticated co-defendant as being the person who's responsible for the crime. So there are many reasons why we need to better understand the true mental capacity of a defendant when we are assessing their criminal conduct. And this is a very difficult task for both lawyers and for judges, which is why we believe it's so important to partner with psychiatry, with psychiatrists who have experience and understanding with mental illness. This last slide is just a reminder that the idea that we don't need to punish people who are insane or who are seriously mentally ill, this is enshrined in every legal code around the world. This is a long-standing principle from the English legal code, making the point that Dr. Khurram did earlier, that there's no purpose. There's no purpose to punishing people who are insane, because we've lost all reason for doing that. There's no benefit to our society for doing that. And so this is just a reminder that these are long-standing principles that we've been guided by for many, many centuries.
Thank you. Thank you, Robin, and thank you for participating. It's 4 o'clock where you live in the morning, so thank you.
That's okay, thank you.
Yeah, thank you. Okay, so as I said, and I promised that I will come back to Ali's case when we'll start finishing off our presentation and opening it up for discussion. But I've just noticed Huma Sahiba and Dr. Faria, Dr. Muzammil, that there is quite a lot of chat going on. Is there anything from the chat, any important question or comment we need to discuss? Because I'm not keeping an eye on the chat box.
So there were a few questions, but I think the Huma Sahiba has answered them. And let me see one more if Dr. Tariq has asked one more thing. Are there any provisions in Pakistan Mental Health Act that can be triggered by a judge or only medical psychiatrists?
Yes. So it is a law passed by the parliament. So it's an act of law, and judge can order and should order. And this is my plea. I will come back to it at the last slide of this presentation. Judge should challenge a lawyer and a psychiatrist that whatever you're presenting in this court today, where does the Mental Health Act stand on that? Has that person's legal and mental capacity been assessed as per the Mental Health Act or not? So yes, judge can invoke the elements of Mental Health Act, because at the end of the day, what judge is trying to do is to exercise justice, but also safeguarding and protecting the rights of the most vulnerable and marginalized people in our society, as was spoken by the DG Sahab in his introduction. So the answer is yes. Okay, should I move on? Okay, so the Ali's case, we were talking about the Ali's case at the beginning, that Ali lives with his parents. He has not worked since leaving school 5 years ago and spending his days with his friends who are involved in the drugs and alcohol scene. Now, Ali's personality began to change a couple of years ago, and he gradually appeared less affable, more remote, isolated, spending time on his own. He started to believe that his parents were holding him back. So he had these grudges towards his parents. His mother obviously got concerned. She approached the doctor with her concerns. She stated to the doctor that Ali was acting strangely and threatening violence towards her. Nobody bothered about it. A few weeks later, when Ali was alone at home, unfortunately, he brutally killed her with a hammer. He then fled the family home, hijacked the bus, stopped by the police, taken into the custody, and in a subsequent trial on a charge of murder, homicide, Ali's lawyer submitted a psychiatric report of Ali and argued that Ali was not criminally responsible for the murder. So obviously the question is that what should a judge expect from a psychiatrist in the report which is submitted? What is it that the judge should be looking for? What is it that would help judge to understand the case, to understand the mental illness, and to understand the connection of the mental illness with the offense? What are the salient basic points? The other issue obviously is the issue of legal insanity. We have been talking about what legal insanity is and how it should be, how it is different from medical insanity. We will talk about that. And another important issue, that if Ali was intoxicated with alcohol or with charas, for example, with afim, ganja, whatever, bhang, at the time of committing that murder, where would the law stand on that? How would the criminal responsibility would be affected by that? So we'll talk about these issues in little bit detail, but can I invite any of our judge colleague here, if they are dealing with Ali's case, अगर अली उनके कोर्ट रूम में है और अली के लॉयर ने साइकियाट्रिक रिपोर्ट सबमिट की है, तो क्या चीजें हैं जो उनके जहन से गुजरेंगी और वो चाहेंगे कि इस रिपोर्ट में वो मेंशन्ड हो? Can anybody say anything about it? Okay, so sorry.
Sir, I'm guessing few people are talking, but they're not unmuting themselves. So please, अगर आप खुद से mute ना करें, तो please raise your hand so we can unmute you.
जो आपको बात करते हुए नजर आ रहे हैं, जफर इकबाल नईम साहब ने रेज हैंड किया है. जी, we can hear you, Zafar Iqbal sir.
Thank you. Doctor, to my mind, the psychiatrist is supposed to ascertain whether the unemployment phase of life of Ali had affected his mental health by asking some psychological questions to him. I think this would be the more important aspect for determining his medical
जी
insanity before
जी जी
determination of his
जी जी
issues.
बिल्कुल I totally
This is my
जी
view.
जी I agree with you. And before I take your point further, Zafar Sahab, are there any other comments or questions?
No, sir. Thank you.
Thank you. So, no, you are right. I mean, what psychiatrist should be producing in his report is a story, is a life history of this person. So starting right from when that person, where that person was born, what was his childhood like, were there any issues in regards to abuse of any kind, physical abuse, emotional abuse, sexual abuse. Um, Rao Saab, we will come back to you in a second. And then the psychiatrist should tell you that what was that person's schooling like. For example, was he bullied in the schooling? How was he in his studies? Did the antisocial problems start in the police by, for example, disrespecting teachers? For example, smoking cannabis? The psychiatrist should also be commenting on what did that person do immediately after leaving the school? Did they work or did they just sorry, go into the drug scene and antisocial scene? The psychiatrist should also be telling you that what the relationship with the parents like, what the relationship with the brothers and sisters like. Is he married or not? Has he got children or not? The psychiatrist should also tell you whether there is a previous history with his physical health problems, with his mental health problems. Psychiatrist should also be telling you whether this person has ever committed any previous offenses. And if he has committed any previous offenses, what happened about those offenses? Was he charged? Was he convicted? Was he sentenced? Was mental illness played a part or raised in one of those previous offenses or not? And most importantly, in psychiatry, we psychiatrists are not privileged like other specialists who have the advantage of investigatory methods like blood tests and this test and that test. We have not yet developed tests to assess mind. So what we have is what we call a mental state examination. So the judge should also expect a psychiatrist to tell the mental state of that person. So what that person look like, how that person speak, if there's any problem with that person's speech, if there any problem with that person thinking in terms of either thinking any strange ideas or is not able to think clearly. The psychiatrist should also tell the judge whether that person has some sort of problem in terms of understanding the reality around him. Is he hallucinating? Is he hearing voices? Is he seeing things? The psychiatrist should also be telling the judge whether that person has ever harmed himself in the past. Has he got any suicidal ideation? Has that person got any homicidal ideation? Is he having any thoughts and urges to murder other people? The psychiatrist should also be telling to the judge whether this person is conscious enough to be communicated reasonably and meaningfully. And finally, the psychiatrist should also be telling the judge whether this person has got enough attention and concentration to talk. Has this person got reasonable amount of memory to remember what has been talked? Or has he got any memory in terms of the offense, where the offense was committed? So broadly speaking, this is how we produce a court report. Before I talk more, Rao Saab raised his hand. Can I take that question just now?
Sir, Arshad Mahmood Saab is also wanting to say something, so if we can include him.
Please, go ahead.
Assalamu alaikum, everyone.
Assalamu alaikum, Arshad Saab.
I tried to communicate earlier, but I was unlucky to have
I'm sorry.
microphone unmuted. I raised hand number of times to raise question actually on earlier part of your discussion, especially the interview of the mentally ill person when he firstly apprehended and brought before the police. I think police is not capable of interviewing that person and knowing that whether he is a mentally fit person or not.
जी
Therefore, in my opinion, there should be a change in the law that some expert, medical expert or mental health expert should be associated
जी
with this interviewing process, so that in future when the person is practically charged in the court of law or brought before any competent forum, there should be an initial expert opinion that what answers were given by that person or
जी
what is his mental capacity. I
जी
think the law is silent on this aspect. What do you say?
जी मैं आपका सवाल जब सुन रहा था तो मेरे जहन में I was thinking about how we work here, what happens here, the system in the UK system where I work in. So believe me, many police officers, many police constables here are also not that aware of mental health problems and how they present, and they apprehend someone, and sometimes they just proceed with the case. They just charge them, they caution them, they charge them. And when that person is given access to the lawyer, most of the time, the lawyers raise this issue that police had cautioned this person, police has charged this person, but I don't think this person has got the necessary mental capacity to understand what was being talked in the police interview. And for that reason, the police interview then become void, null and void. So what I'm trying to say here is that I take your point that majority of the police officers or police constables in Pakistan wouldn't be able to identify or understand the issue of mental illness at that early stage. But then there are speed breakers further during the process. So at the time of engagement with the lawyer, they can raise this issue. At the time of trial, the judge can raise this issue. Your point about what should be done about it. So as I understand it, the Mental Health Act of Pakistan or Mental Health Act of Punjab or Sindh, whichever province you are in, exactly ask you to do that. They ask you to safeguard the rights of the person. So as how I have understood it, Arshad Saab, as how I have interpreted it, is that the law is present. The law is there. The Mental Health Act law is passed by the parliament, so it's an act of law. The only problem is its meaningful implementation and embedding in the process. So what we have been trying to do is we have developed, the Pakistan Psychiatric Society and myself, we have developed this program of Mental Health Act. We have delivered it twice in person in Karachi and Rawalpindi. We have been doing webinars on it. And what we are trying to do is to target not only the lawyers, not only the psychiatrists, but also other professionals from the criminal justice system. So such as the social workers, the police inspectors, the police officers. So I think the way to go about it is to educate people, is to aware them about that there is this law present and this law asks you to do this. So if I ask you, Arshad Saab, that I don't agree with you with respect that the law is silent, I think the law is not silent. We have got Mental Health Act there. Would you agree with me, or would you say no?
Sir, I would like to say that being practically doing some cases of mentally ill people, I have
Yes.
noticed that none was identified at the time of registration of the FIR or
Ji.
at the time of investigation, but it was only at the time of trial that
Yes.
either the court itself recognized that this is a person of unsound mind, or
Ji.
somebody pointed out.
Ji, ji.
Actually, no help was sought from the law, or no help was extended by the police or investigation agency that
Yes.
this person is mentally ill capable and has certain right to be protected. So
Ji.
it is my point I wanted to
Ji.
raise, actually.
Yeah, and it's a valid point. It's a valid point, and this is what we are trying to do to address these challenges. But मैं एक चीज़ ये कहना चाहता था कि ये जिस सिस्टम में मैं यहाँ पे काम करता हूँ, इतना सिविलाइज्ड एडवांस सिस्टम है, बिलीव मी अर्शद साहब, यहाँ भी मिसकैरेज ऑफ जस्टिस होता है। यहाँ भी अक्सर हमको ऐसे केसेस देखने को मिलते हैं कि वो ट्रायल स्टेज पे जाके जो है पता लगता है कि अरे भाई इसके साथ तो मसला शुरू से ही था, और फिर सारी चीज को जो है रोल बैक करना पड़ता है। तो मेरी कोशिश यही है कि ये जो गैप है, इंटरफेस है लॉ और मेंटल हेल्थ के दरमियान, और लॉ में सारे लोग शामिल हैं, पुलिस से लेके लॉयर्स से लेके जजेस से लेके, उनके दरमियान गैप को कम किया जाए।
सर सॉरी टू कट यू, मैं जो बात स्ट्रेस करना चाह रहा था दैट वाज कि एट द टाइम ऑफ रजिस्ट्रेशन ऑफ द एफआईआर इट शुड नॉट बी लेफ्ट ओनली टू द पुलिस कि वो आइडेंटिफाई करे और उसको सपोर्ट करे, बट अब if there is somebody who is expert in the mental health or is a doctor, he should be associated in from the very beginning so that the rights of the person are very well protected.
जी हाँ, सो इसको सेव गार्ड करने के लिए इस पॉइंट को जो यहाँ पर होता है वो ये एक, यहाँ पे एक पुलिस स्टेशंस के अंदर एक डॉक्टर्स होते हैं, उनको हम कहते हैं फोरेंसिक मेडिकल एग्जामिनर्स। सो होता ये है कि जब भी कोई शख्स अरेस्ट होता है तो पुलिस यूजुअली फोरेंसिक मेडिकल ऑफिसर को बोलती है कि भाई इसको एग्जामिन करो और हमें बताओ कि इसके साथ कोई मसला है, साइकियाट्रिस्ट को इन्वॉल्व करना है या नहीं करना। आई थिंक आपका यही पॉइंट है कि
ये अब देखें इस लॉ में देयर इज अ स्कोप कि फोरेंसिक मेडिकल एक्सपर्ट शुड बी इंक्लूडेड देयर इन, who should be available at some district level or some police station level. So if some case of some mentally retarded person comes there, he should be available to look into.
जी, absolutely. I take your point. और शायद आप इसी हवाले से कह रहे थे कि the law is silent in that regard. जी, बहुत शुक्रिया। आई थिंक 2-4 लोगों ने हाथ खड़े किए हैं, जफर साहब भी हैं और किसी और साहब ने भी हाथ खड़ा किया था, प्लीज उनको अनम्यूट कीजिए।
Dr. Saab, Mr. Amjad Nazir Chaudhary has a question and I have unmuted him.
जी
Sir, Amjad Nazir Chaudhary sir, please.
जी अमजद साहब, प्लीज बात कीजिए, गो अहेड।
Sir, we may move to the next request for question. Mr. Iqbal Ahmed DJ Godki. I think Mr. Amjad is online and unmuted his mic. Sir Amjad Nazir Chaudhary sir, please.
अनम्यूटेड तो कौन है साहब?
जी इकबाल साहब बात कीजिए।
अस्सलाम वालेकुम।
वालेकुम सलाम।
अच्छा, आपने जो ये प्री ट्रायल की स्टेज की बात की थी तो उसके लिए मेरे हिसाब से एक लॉ में अमेंडमेंट होगी, 167 सीआरपीसी में एक अमेंडमेंट होती है, क्योंकि होनी चाहिए, क्योंकि प्री ट्रायल स्टेज तो हमारा होता है मजिस्ट्रेट से शुरू है, जब पुलिस उनको लेके आती है रिमांड पर्पस के लिए। तो अगर 167 सीआरपीसी में अमेंडमेंट हो जाएगी कि बिफोर रिमांडिंग द अक्यूज इन कस्टडी ऑफ द पुलिस और इन judicial custody, then there must have been the accused be produced before the psychiatrist for getting his opinion. Otherwise ये पूरी की पूरी एक्सरसाइज जो है null and void हो जाएगी।
जी। So your point is about requirement of an amendment in 167 CRPC.
CRPC, yes.
जी, बहुत शुक्रिया। दो चार
हैं। You suggest whether it would have been done or not.
जी इकबाल साहब प्लीज, क्या कह रहे हैं आप?
ये अमेंडमेंट होनी चाहिए या नहीं चाहिए?
जी हाँ, in order to facilitate the process.
खास के अगर आपने ये कहा था कि जिन ममालिक में आप रह रहे हैं वहाँ पे भी ये मिसकैरेज ऑफ जस्टिस होती है और आखिरी स्टेज पे जाके पता पड़ता है मेंटल इलनेस का।
जी।
यहाँ तो बिगनिंग में आपने प्री ट्रायल की भी तो बात की थी ना, प्री स्टेज की भी बात की थी, तो प्री स्टेज तो यहाँ पाकिस्तान में होता ही यहाँ से है। 167 इज द प्री स्टेज।
ये मैं इकबाल साहब के पॉइंट को सपोर्ट करता हूँ कि दिस इज वेरी वैलिड पॉइंट, ये अमेंडमेंट होनी चाहिए। दीज आर द लूप होल्स आई थिंक जो मैं भी पॉइंट
जब तक यहाँ। और दूसरी बात ये है कि हमारे पाकिस्तान में बहुत से अजला में मेडिको लीगल ऑफिसर नहीं है, तो साइकियाट्रिस्ट कहाँ से आएंगे?
जी हाँ, ये चैलेंजेस तो हैं इकबाल साहब, नशर साहब, ये चैलेंजेस तो हैं कि पाकिस्तान में जो suitably qualified psychiatrists हैं, I think इकबाल साहब आपको सही बता पाएंगे, but I think the number is around 500 और population कितनी है, तो ये challenges अपनी जगह पे हैं।
पॉपुलेशन को छोड़ के आप अजला को काउंट करें ना, कितने अजला है और कितने साइकियाट्रिस्ट हैं आपके पास।
जी हाँ, ये बात दुरुस्त है, लेकिन हम ये कोशिश कर रहे हैं कि जो लोग क्रिमिनल जस्टिस प्रोसेस में इन्वॉल्व हैं, उनकी नॉलेज और अवेयरनेस को कुछ इस हद तक ले आया जाए कि वो कम से कम ये चीज को डिटेक्ट कर लें कि इस बंदे के साथ कुछ क्रेजीनेस है, इस बंदे के साथ कोई मसला है। जी प्लीज हयात साहब।
167 के हवाले से जो क्वेश्चन हुआ उसमें थोड़ा सा मैं इंटरवीन करता हूं। दरअसल इट इज द एप्लीकेशन ऑफ माइंड ऑफ द मैजिस्ट्रेट, उसमें अमेंडमेंट की जरूरत नहीं है। वहां अल्फाज लिखे हुए हैं कि इन सच कस्टडी ऑफ सच में एज थिंक्स फिट। मैजिस्ट्रेट अगर फिट फील करता है कि इस आदमी को कस्टडी में जाना चाहिए तो ही इज टू सेंड हिम टू कस्टडी। नाउ व्हाट इज फिटनेस? हियर द मैजिस्ट्रेट नीड्स टू यूज हिज माइंड। इफ ही फील्स that the person is mentally sick or mentally ill, he is supposed to refer him straight away to psychiatrist, और उसे कस्टडी नहीं देनी चाहिए। मेरा ख्याल है अमेंडमेंट, हम यहाँ एक रिसर्च भी कर रहे हैं और हमें एक चीज का बड़ी शिद्दत से एहसास हो रहा है कि हमारे मैजिस्ट्रेट्स अपनी ड्यूटी को नहीं समझते हैं। वो एज अ पोस्ट ऑफिस काम करते हैं, इवन 167 में भी, 344 में भी, 190 में भी, 193, जो भी उनके पास प्रोविजंस हैं, अनफॉर्चुनेटली दे डोंट अप्लाई देयर माइंड। लेकिन अगर मैजिस्ट्रेट के पास मुल्जिम को पेश करने का मकसद ही यही होता है कि मैजिस्ट्रेट ये देखे कि आया इज ही फिट टू बी गिवन इनटू द कस्टडी, और यही वजह होती है, देखें कस्टडी से पहले उसका मेडिकल कराया जाता है। आप मुल्जिम को भेजते हैं डॉक्टर के पास बिफोर कस्टडी की, आप इसको एग्जामिन करें, फिर आप कहते हैं कि कस्टडी के वापस आके दोबारा उसका मेडिकल आप करवाते हैं, और डॉक्टर नॉर्मली लिखता है ही इज फिट एंड ऑफ साउंड माइंड, 2 लफ्ज लिखता है और आप भी उसके ऊपर कस्टडी मैजिस्ट्रेट दे देता है। तो यहाँ बेसिक जो चीज है वो है एप्लीकेशन ऑफ माइंड ऑफ द मैजिस्ट्रेट। आई थिंक देयर इज नो नीड ऑफ अमेंडमेंट इन द 167 CRPC।
थैंक यू।
इफ आई एम क्लियर, एम आई क्लियर?
जी हाँ, मैं तो समझ गया हूँ, लेकिन बाकी लोगों का मुझे भी आइडिया नहीं है।
फिजिकल हेल्थ और मेंटल हेल्थ दोनों अलग चीजें हैं। कि कहीं पुलिस उसको फिर टॉर्चर ना करे, इसके लिए
देखिए ये मेंटल हेल्थ और फिजिकल हेल्थ में कोई फर्क नहीं है। फिटनेस
मैं समझता हूँ डॉक्टर साहब मौजूद हैं, वो ज्यादा बता देंगे कि दोनों अलग चीजें हैं। विद ड्यू रिस्पेक्ट,
मैं कुछ कहूँ,
मैं अर्ज कर लूं थोड़ी सी, मैं आपको बता दूं फिर आप
जी प्लीज।
मेंटल और फिजिकल फिटनेस, देखिए वो आप फिटनेस लिखता होता है कि ही इज फिट इन एंड ऑफ साउंड माइंड, इन वो उसको वर्ड यूज करते होते हैं कि इन प्लेस, इन स्पेस एंड क्या है वो लफ्ज यूज करते हैं वहां पे,
टाइम, प्लेस एंड पर्सन।
यस, ही इज फिट इन टाइम एंड स्पेस और समथिंग, वो
जी।
उसका मतलब ये होता है कि फिजिकली भी फिट है और ये मेंटली भी फिट है। अगर वो मेंटली फिट नहीं है तो डॉक्टर इज टू राइट दैट ये आदमी मुझे मेंटली ठीक नहीं लगता
जी,
ठीक है ना। तो मैजिस्ट्रेट को अगर फर्ज किया ये नजर आ गया कि आदमी पागल है, पागलों की हरकतें कर रहा है, नजर पागल आ रहा है, तो ही शुड सेंड हिम टू साइकियाट्रिस्ट। लेकिन अगर उसको नजर नहीं आता देन इट इज ड्यूटी ऑफ द डॉक्टर। लेकिन मैजिस्ट्रेट की फिर ये ड्यूटी है कि डॉक्टर की तरफ से जब फिटनेस आती है तो वो सिर्फ कागज पे रिलाय ना करे। तो आई थिंक देयर इज नो नीड ऑफ अमेंडमेंट इन दैट।
मैं सिर्फ इस हवाले से बात करना चाहता था कि फॉर एग्जांपल फिटनेस फॉर ट्रायल की जहां तक बात है, वो सिर्फ मेंटल इनकैपेसिटी के हवाले से नहीं है, वो फिजिकल इनकैपेसिटी के हवाले से भी है। सो जो क्राइटेरिया हम लोग फॉलो करते हैं वो ये है कि अ पर्सन इज एबल टू पार्टिसिपेट इन द क्रिमिनल प्रोसीडिंग्स और द ट्रायल स्टेज, not only mentally but also physically. So if is there a mental problem or is there a physical problem, then we say that he's not able to participate meaningfully in the trial against him. मैं ये थोड़ा सा रिक्वेस्ट करना चाह रहा था, हुमा साहब से भी ये बात हुई थी। अगली जो 2 स्लाइड्स हैं, दे आर वेरी वेरी इंपॉर्टेंट स्लाइड्स, और ये जो इश्यूज हम बात कर रहे हैं इनको फर्दर एक्सप्लेन करेंगी। लेकिन 2 मिनट का जो है अभी ब्रेक की बात हुई थी, तो 2 मिनट का ब्रेक इस वक्त मैं करना चाहता हूँ। किसी को अगर फ्रेशन अप होना है तो हो लें। We will resume again after 2 minutes from where DG Saab have left things with.
Before proceeding further, there were 2 people, I think.
Please go ahead.
Naeem Saab wanted to say something, and then Dr. Tariq had to say something.
Sure, please go ahead.
Dr. Saab, my learned brother Arshad Mahmood raised a very valid question that there must be some provision in the Mental Health Act providing an expert at the time of interview of a lunatic accused just soon after registration of FIR and during interrogation or investigation. So this is also a requirement of Article 10A. At international level, we see that there is a convention which is called International Covenant on Civil and Political Rights. Article 57 or 58 of that covenant provides the right of defense to an accused during investigation, the right of a defense counsel even at the time of investigation, even moreover a right to have an interpreter even during investigation at the very inception of the interrogation against him. So similarly, I think Raja Arshad Mahmood has rightly raised this question that there must be some amendment in the Mental Health Act providing a right to such an lunatic, that there must be a mental expert at the time of his interview by the police. It would ensure his right of fair trial. It's my.
जी, जफर साहब, एक बात ये कहना चाहता था इस हवाले से कि मेंटल हेल्थ एक्ट का पर्पस क्या है? व्हाट इज द पर्पस ऑफ मेंटल हेल्थ एक्ट? द पर्पस ऑफ मेंटल हेल्थ एक्ट इज टू सेफगार्ड द राइट्स ऑफ मेंटली इल पीपल. अब वो जो आप बात कर रहे हैं वो तो पुलिस स्टेशन से शुरू हो जाती है वो चीज कि किस तरीके से उस स्टेज पे उस बंदे के राइट्स को सेफगार्ड किया जाए. लेकिन प्रॉब्लम यह है कि इसको फैसिलिटेट कैसे किया जाए. मतलब जो एक पुलिस ऑफिसर है उसको ये कैसे पता हो कि भाई एक लॉ है जिसका नाम है मेंटल हेल्थ एक्ट, और मेंटल हेल्थ एक्ट जो है वो मुझे कंपेल करता है कि मैं इस बंदे के खिलाफ कुछ भी नहीं करूं, ना एफआईआर का सोचूं, ना इससे बात करूं, जब तक कि ये डिटरमिन नहीं हो जाए कि ये साउंड माइंड का है या नहीं है. अब वो उसके पास तो एक्सपर्टीज है नहीं, उसको डॉक्टर से पूछना है. अब वो डॉक्टर से पूछने का क्या मैकेनिज्म हो, साइकाट्रिस्ट को इन्वॉल्व करने का क्या मैकेनिज्म हो, तो ये सारी चीजें जो हैं ये Mental Health Act does not talk about that how you should go about these things. Mental Health Act gives you the principles and the guidelines. As long as the procedural aspect of is concerned, this is what we are trying to do by improving the awareness of police, lawyers, doctors and judges. बात यह है कि अगर कोई एक जज जो है वो अगर ये इशू रेस कर दे कि भाई ये तुम इसको लेकर आए हो इधर मेरे कोर्ट में, तुमने जब इसके खिलाफ एफआईआर काटी थी तो उस वक्त तुमने जो है ये सोचा था कि ये तो बात ही तुमसे सही नहीं कर रहा है. तो जब तक ये चैलेंजिंग नहीं शुरू होगी, जब तक ये सिस्टम चैलेंज करना नहीं शुरू करेगा लोगों को, उस वक्त तक प्रोसीजर्स डेवलप नहीं होंगे. ये जिस सिस्टम में मैं काम करता हूँ यहाँ भी आई कीप कमिंग बैक टू दिस इशू दैट यहाँ की जो जुडिशरी है, यहाँ के जो लॉयर्स हैं, उन्हीं की महरूने मिन्नत है इन द लास्ट 20-25 ईयर्स के मेंटल हेल्थ एक्ट जो है वो इम्प्लीमेंट हुआ है और लोगों के राइट्स जो हैं वो सेफ गार्ड हो रहे हैं. वरना मैं खुद एक साइकाट्रिस्ट हूँ और मुझे ये कहने में कोई आर नहीं है कि मेजॉरिटी ऑफ साइकाट्रिस्ट जो हैं वो प्लेग की तरह भागते हैं लॉयर से और कोर्ट से दूर, क्योंकि जाहिर है आपको चैलेंज करते हैं, लॉयर्स आपको चैलेंज करते हैं कि भाई जस्टिफाई करो अपना डायग्नोसिस, जस्टिफाई करो कि तुमने इस शख्स की लिबर्टी को जो है वो क्यों वायलेट किया है. So I totally agree with you. The procedural aspect is what is lacking in Pakistan, but this is what we are trying to do, and we are very hopeful that inshallah we'll get there. There are other hands as well. District and Session Judge Karachi West has raised their hand, please.
Sir, pehle Dr. Tariq was in the line, so can we ask him to come along?
Yes,
मैं
yes,
सिर्फ
sure.
2 मिनट लूंगा. थैंक यू, बहुत बहुत शुक्रिया. थैंक्स एवरीबॉडी. मेरा नाम डॉक्टर
Thank
तारिक, मैं भी फ्रेंसिक साइकियाट्रिस्ट हूँ, कनाडा में काम करता हूँ. बहुत ज़बरदस्त डिस्कशन हो रही थी. मैं सिर्फ 1 मिनट लूंगा. ये जो बात है अमेंडमेंट्स की और CRPC में या वेरियस प्रोसीजर्स में अमेंडमेंट की, कुछ हद तक मैं एग्री भी करता हूँ, लेकिन जो पहला स्टेप है इस सारे सिलसिले का, थैंक्स टू खुर्रम एंड हिज टीम फॉर पुटिंग दिस टॉक टुगेदर, सारा जो बेसिक काम है वो है ये है कि हम एक आहिस्ता आहिस्ता एक कल्चर को चेंज करें. आहिस्ता आहिस्ता हम अपने प्रैक्टिस के अंदर सोचें कि मेंटल हेल्थ इश्यूज को हम किस तरह रेज करें. और जो दूसरा बड़ा जो इम्पोर्टेंट स्टेप है, जो इकबाल साहब ने इम्पोर्टेंटली रेज किया, वो ये कि बड़े शहरों में ठीक है, बड़े शहरों में आपके एक रिलेशनशिप होती है एक यूनिवर्सिटी के साथ, एक साइकेट्री इंस्टीट्यूशन के साथ, लेकिन इंटीरियर पंजाब, इंटीरियर KPK, इंटीरियर सिंध में जहाँ पे ये रिसोर्सेज नहीं है, तो वो क्या करेंगे? क्योंकि हम नहीं चाहते कि जो कनाडा का सिस्टम है या UK का सिस्टम हम यहाँ पे ट्रांसप्लांट करें, वो तो बिल्कुल ही नहीं चलेगा. लेकिन एक कल्चर को चेंज किस तरह किया जा सकता है, और एक जो रिसोर्सेज हैं, ख़ास तौर जो इंटीरियर जो एरियाज़ हैं, वो किस तरह हम चेंज करें, इस पे फिर मतलब वो तो एक ब्रॉडर डिस्कशन होगी. तो
जी जी,
थैंक यू.
बहुत बहुत शुक्रिया तारिक साहब. This is the question, this is the X point, X factor here, isn't it? So बहुत बहुत शुक्रिया ये रेज करने का. जज साहब वेस्ट कराची, last question before we move on to the next slide, which I really want to talk about, which is very important from a judge perspective. So Karachi West, Judge Saab, please go ahead.
अस्सलाम वालेकुम.
Assalamu
जब ये बात हो रही थी सेक्शन 167 में अमेंडमेंट की, तो उसको अगर पढ़ा जाए तो ये हमारा लॉ इतना हैंडीकैप नहीं है. 167 में कोई अमेंडमेंट की जरूरत नहीं है, क्योंकि मजिस्ट्रेट के पास बहुत सारे अख्तियारात होते हैं. मजिस्ट्रेट इज द हीरो ऑफ CRPC. आप अगर उसको देखें
जी,
हर काम उसने ही करना है. रिमांड के टाइम पे जब अक्यूज को पेश किया जाता है ड्यूरिंग इन्वेस्टिगेशन, तो उससे क्वेरीज करना भी जो है मजिस्ट्रेट की एक रिस्पॉन्सिबिलिटी होती है. और उस ड्यूटी को डिस्चार्ज करते हुए वो डिफरेंट टाइम से जो डिफरेंट ऑर्डर्स पास करता है.
जी,
बिल फर्ज एक अक्यूज जो है, ही इज गोइंग टू मेक कन्फेशन ऑफ एन ऑफेंस. तो उस कन्फेशनल स्टेटमेंट के लिए भी उसको एक स्क्रीन आउट करना होता है उसने, कि आया वो कन्फेशन कितनी इफेक्टिव है और कितनी इनफेक्टिव है. उस हवाले से डिफरेंट क्वेरीज की जाती हैं. अच्छा, उन क्वेरीज में अगर कहीं पे भी मजिस्ट्रेट को ये फील हो कि ये जो बंदा है, द पर्सन मेकिंग कन्फेशन इज ऑफ अनसाउंड माइंड, ही इज ड्यूटी बाउंड टू go for his medical examination through psychiatrist.
जी.
Likewise, अगर एक जुवेनाइल उसके सामने आता है, वो कहता है कि मैं जुवेनाइल हूँ, लेकिन वो जुवेनाइल लगता नहीं है, बावजूद इसके ये ड्यूटी होती है एक मजिस्ट्रेट की उसको स्क्रीन आउट करने की.
जी.
लिहाजा मैं समझता हूँ कि 167 में कोई ऐसा डिफेक्ट नहीं है या कोई उसमें कोई कमी नहीं है जिसको पूरा किया जाए. पूरा CRPC भरा हुआ है. अगर 464 को भी पढ़ेंगे तो उसमें भी मजिस्ट्रेट का बहुत बड़ा रोल दिया गया है, इंक्वायरी और ट्रायल. तो मैं समझता हूँ कि 167 में कोई अमेंडमेंट की जरूरत नहीं है अगर पूरे लॉ को पढ़ा जाए तो.
मैं एक सॉरी प्लीज कीप ऑन, स्टे ऑनलाइन. मेरा एक क्वेश्चन है आपसे, अगर आप माइंड ना कीजिए. हेलो, अच्छा, जज साहब आप हैं लाइन पे? ओके. So Amjad Nazir Saab, I will come back to you in a second. Can I just take the next slide on of his discussion के लिए काफी time है जो इंशाल्लाह. So then I just wanted to go to the next slide. So this is what I think. I think that this is what a judge, bare minimum, I think bare minimum, this is what a judge should expect in a psychiatric report from a psychiatrist in his court, a magistrate or whatever level court we are talking about. This is what a psychiatrist should comment on in his report to the court. So is Ali or Abu Asha suffering from mental disorder and as defined under the Mental Health Act? Now this is very important, as defined under the Mental Health Act. अगर आपको legal insanity को establish करना है as opposed to the just medical insanity, I will say it again and I'll reiterate it again and I'll say it again and again. If you want to establish the legal insanity, then you have to ask the psychiatrist to tell you, is that person suffering from a mental disorder? And not just that, is that person suffering from mental disorder as per the Mental Health Act? क्योंकि mental disorder की definition जो है वो Mental Health Act में define की गई है कि कौन सी चीज mental illness है या mental disorder है और कौन सी चीज mental illness या mental disorder नहीं है. बहुत से लोग आपको सड़क पे नजर आ जाएंगे अजीब तरीके से behave करते हुए. उनके बारे में आप कहेंगे कि इनको mental illness है, होगी भी उनको कोई mental health problem. लेकिन in order to establish the legal insanity, the legality of it, you have to establish कि उनका जो mental problem है, उनकी जो mental illness है, that is proven as per the definition of mental disorder as Mental Health Act, Punjab, Sindh, KPK and Balochistan. So that has to be the first thing a judge should be looking for in a psychiatric report. If so, अगर mental disorder है उस बंदे को, तो judge should also challenge the psychiatrist to give an opinion on the form of that mental disorder. A mental disorder तो बहुत तरह के हैं, mental illnesses भी हैं, personality disorders भी हैं, mental impairment भी हैं, बहुत सारे issues हैं. So judge जो है वो psychiatrist से ये भी expect करेगा कि mental disorder का form क्या है, किस तरह की mental disorder है. Judge should also be looking into the report if the accused, in the psychiatrist's opinion, likely to constitute a danger to himself or others at that time or in the foreseeable future. So the risk of harm जो है वो भी psychiatrist को अपनी report में establish करना होगा judge के लिए, bare minimum. दूसरी चीज जो judge should be looking for in a psychiatric report is an opinion from the psychiatrist on section 84 of PPC. And judge should, the psychiatrist should clearly mention that there are reasons to believe that this unsoundness of mind is present, and in such a way that the person is incapable of knowing the nature of the act. So this is important, the nature of the act, and that what he was doing was wrong and contrary to the law. So bare minimum, a psychiatrist should report on this to the judge. Moreover, the judge should also expect, or a lawyer should also expect in the psychiatric report by the psychiatrist to comment on section 465 and 469 of the CRPC, that actually is the person fit for the trial or not, on the basis of the unsoundness of mind and incapacity of participating effectively in the trial. So remember those criteria, whether the person can instruct their solicitor, their lawyer, can they speak to their lawyer about the issue is, does that person understand the difference between pleading guilty and not guilty? Does that person understand what the court is all about, that there's a judge, there's a lawyer, there's a prosecutor? Does that understand that there's an evidence which is given in the court against him and for him? Does that person understand that if he disagree with anything at all, which is said in the court during his trial, what is he supposed to do? क्या खड़ा होके चिल्लाना शुरू कर देगा? ऐसा नहीं है. उस शख्स को ये पता होना चाहिए कि अगर कोई ऐसी चीज बोली जा रही है कोर्ट में जो एब्सोल्युटली अनट्रू है, रॉन्ग है, फॉल्स है, तो मुझे क्या करना है, जो कि यूजुअली होता है कि आप अपने लॉयर से बात करते हैं और लॉयर्स फिर उसको पुट फॉरवर्ड करता है कोर्ट को. सो बेसिक अंडरस्टैंडिंग होनी चाहिए जो साइकियाट्रिस्ट अपनी रिपोर्ट में बताए कोर्ट को, जज को. सेकेंडली, इज द पेशेंट इन नीड ऑफ ट्रीटमेंट? क्या उसके साथ कोई मेंटल इलनेस है? मेंटल इलनेस के लिए ट्रीटमेंट जरूरी है, और वो ट्रीटमेंट जो है उसका मेमोरी के ऊपर क्या इफेक्ट होगा, स्पेशली इन रिगार्ड्स टू द इश्यू सराउंडिंग द अलेज्ड ऑफेंस और इस फिटनेस टू प्लीड. सो कभी कभी ऐसा होता है कि लोग बहुत ज्यादा एंग्शियस होते हैं, अराउजल लेवल बहुत ज्यादा होता है, और हम उनको डायज़ेपाम या पाकिस्तान में क्या नाम है डायज़ेपाम का, Xanax, I think, अगर वो भी बहुत ज्यादा दे दी जाए तो उससे कॉन्शियस लेवल कम हो जाता है. कॉन्शियस लेवल कब होगा तो उस पर्सन की इफेक्टिवली पार्टिसिपेट ट्रायल में करने की सलाहियत कम होगी. तो ये इस तरह के इश्यूज भी जो है वो साइकियाट्रिस्ट शुड से इन देयर रिपोर्ट. Can that person be suitably cared in the hospital? अगर साइकियाट्रिस्ट कोर्ट को ये बता रहा है कि भाई ये बंदे के साथ मेंटल इलनेस है और ये इलनेस ऐसी है जिसने हो सकता है इसको ऑफेंस करने पे मजबूर किया हो और हमें इसका ट्रीट करना है, तो वो शुड टेल टू द कोर्ट कि आप परेशान ना हो, हम इसको हॉस्पिटल में एडमिट करेंगे अंडर मेंटल हेल्थ एक्ट और बेड भी अवेलेबल है. ऐसा नहीं है, क्योंकि जज को तो ये एंग्जाइटी भी होगी कि अगर मैं इस बंदे को अभी यहाँ से जाने दूं तो पता नहीं ये कहाँ चला जाए, पता नहीं हॉस्पिटल के अंदर जाता है या नहीं जाता है. अगर हॉस्पिटल के अंदर जाता भी है तो लॉक्ड एनवायरनमेंट में रहता है नहीं रहता है. अब अली अगर है आपके कोर्ट में और उसकी मेंटल इलनेस इतनी प्रोफाउंड है तो कोई भी जज कंफर्टेबल नहीं होगा अली टू अलाउ अली टू वॉक ऑन द स्ट्रीट्स, क्योंकि अली माइट ऑफेंड अगेन, माइट मर्डर समबडी अगेन. And finally, a psychiatrist should report in his should mention in his report to the court whether they are related to the person or not, whether they have any pecuniary interest in that person trial or not. So ऐसा नहीं हो कि मेरा मामा चाचा जो है उसकी मैं रिपोर्ट बना रहा हूँ और कोर्ट में सबमिट कर रहा हूँ. So there is a conflict of interest. So I should clearly say that I'm not related to that person at all. I do not have any interest in that person trial or his custody into the prison or his release on the bail or whatsoever. और finally mental health act पंजाब, सिंध, KPK, बलूचिस्तान जो है उसमें ये प्रोविजन है जिसको हम कहते हैं approved psychiatrist. So approved psychiatrists are psychiatrists who have a training program of mental health act जो हमने डेवलप किया है पाकिस्तान साइकियाट्रिक सोसाइटी के साथ. और हम ये कोशिश कर रहे हैं कि जिन जिन साइकियाट्रिस्ट ने वो ट्रेनिंग प्रोग्राम को अटेंड किया है और इन अदर वर्ड्स दे हैव गॉट द नॉलेज ऑफ द मेंटल हेल्थ एक्ट एंड हाउ इट शुड वर्क टू सेफगार्ड द राइट्स ऑफ द मेंटली डिसऑर्डर्ड पीपल, उनको अप्रूव्ड साइकियाट्रिस्ट कहा जाए और उन्हीं की एविडेंस जो है वो कोर्ट ऑफ लॉ में सिर्फ एप्लीकेबल हो whenever the issues of the interface between law is concerned. तो ये आफरीदी साहब इसके बारे में आपको और बताएंगे कि अप्रूव साइकियाट्रिस्ट के हवाले से क्या क्या जो है वो अभी तक डेवलपमेंट्स हुई हैं. फाइनली मैं ये बात कर रहा था कि लीगल इंसैनिटी वर्सेस मेडिकल इंसैनिटी, इसके हवाले से बहुत बात हुई है कि लीगल इंसैनिटी क्या है और लीगल इंसैनिटी को किस तरीके से जो है वो डिफाइन किया जाए. देखिए, लीगल इंसैनिटी, एनी मेडिकल insanity or any psychiatric insanity can be a legal insanity, but not all legal insanity can be a medical insanity. This is a very important point. So legal insanity in a nutshell यही है कि एक बंदे के साथ mental illness है, उसकी mental illness इतनी severe है कि उसकी जो सोचने समझने की सलाहियतें हैं उन पे अफेक्ट हुआ है, उसकी वजह से उसने जो ऑफेंस कमिट किया उसके साथ मेंटल इलनेस का एक कनेक्शन है, और इस तरीके का कनेक्शन है कि उस बंदे को ना ये पता था कि वो कर क्या रहा है और ना ये पता था कि जो वो कर रहा है वो अगेंस्ट द लॉ है. अब इस सारी चीज का जो स्टार्टिंग पॉइंट है वो मेंटल इलनेस है. सबसे पहली चीज ये है कि मेंटल इलनेस होनी चाहिए, मेंटल डिसऑर्डर होना चाहिए, और वो मेंटल डिसऑर्डर जो है वो पाकिस्तान के चारों मेंटल हेल्थ एक्ट जो हैं उन्होंने डिफाइन किया हुआ है, उन्होंने बताया हुआ है कि कौन सी चीज है जो मेंटल इलनेस, मेंटल डिसऑर्डर है और कौन सी चीज है जो मेंटल डिसऑर्डर नहीं है. ये बहुत इंपॉर्टेंट स्लाइड है और इस पे थोड़ी सी तवज्जो की जरूरत है, क्योंकि पाकिस्तान के जो चारों प्रोविंस हैं उसमें स्लाइड डिफरेंसेस हैं डेफिनेशन ऑफ मेंटल डिसऑर्डर में. तो जो सिंध है वो पंजाब से थोड़ा सा डिफरेंट है, और ये चीज़ बहुत इंपॉर्टेंट है क्योंकि ये लीगल इंसैनिटी को अफेक्ट करती है. तो एक बंदे ने अगर सिंध में एक क्राइम किया है और उसकी लीगल इंसैनिटी जो है वहाँ पे डिटरमिन हो रही है तो उसका क्राइटेरिया डिफरेंट होगा, क्योंकि मेंटल डिसऑर्डर की डेफिनेशन डिफरेंट है अंडर सिंध मेंटल हेल्थ एक्ट एज अपोज टू द पंजाब मेंटल हेल्थ एक्ट. सो ये मैं पढ़ देता हूँ आपके लिए. ये हमारा आज का प्रोग्राम का मकसद मेंटल हेल्थ एक्ट की टीचिंग नहीं है, उसका वेबिनार एक हम रखेंगे अगले महीने, लेकिन अगर आप इसमें देखें तो देयर आर सटल डिफरेंसेस. सो सिंध ये कहता है, सिंध मेंटल हेल्थ एक्ट सेज दैट मेंटली इल पर्सन इज हु इज इन नीड ऑफ ट्रीटमेंट बाय रीजन ऑफ एनी डिसऑर्डर ऑफ द माइंड, कोई भी डिसऑर्डर हो माइंड का, अदर देन मेंटल इम्पेयरमेंट एंड सीवियर पर्सनैलिटी डिसऑर्डर.
पंजाब कहता है any mental illness including mental impairment, severe personality disorder, severe mental impairment and any other disorder or disability of mind. KPK कहता है mental disorder means mental illness, mental impairment, personality disorder and any other disorder or disability of mind. Balochistan कहता है mental disorder means mental illness, mental impairment, severe personality disorder, severe mental impairment and any other disorder or disability of mind. So आप देखिए there are these subtle differences in different jurisdictions and that would affect the applicability of the legal insanity. क्योंकि remember legal insanity determine करने का स्टार्टिंग पॉइंट ये है कि मेंटल डिसऑर्डर को डिफाइन किया जाए एज पर द मेंटल हेल्थ एक्ट। और एक और इम्पॉर्टेंट चीज ये है कि मेंटल हेल्थ एक्ट आपको ये भी बताता है कि कौन सी चीज है जो कि मेंटल डिसऑर्डर नहीं है। सो विच मेंटल एबनॉर्मैलिटी इज नॉट कंसिडर्ड अ मेंटल डिसऑर्डर एज पर मेंटल हेल्थ एक्ट ऑफ all the provinces and hence cannot be used in terms of legal insanity. So promiscuity is not a mental illness as per Mental Health Act. Sexual orientation, so homosexuality, bisexuality, ये जो है वो mental illnesses नहीं है, despite of the fact that the prevalence of mental health problems in, for example, in a homosexual or bisexual person is proportionality sometimes higher than heterosexual people. Sexual deviancy, so कुछ लोगों के sexual interests होते हैं animals में, कुछ लोगों के sexual interests होते हैं inanimate objects में. मुझे याद है कि चंद सालों पहले मेरा एक patient था, उसको sexual interest था babies की nappies में, जो soiled nappies होती हैं, babies की soiled nappies, उसमें वो masturbate करता था. He had sexual interest in that, but that आप उसको अगर सोचें, so you cannot comprehend it, and you will say that something is bloody wrong with his mind. Not according to the Mental Health Act. Transsexualism. So there are some people who feel that they are born in the wrong gender. कुछ लोग ऐसे होते हैं जो जिनको लगता है कि they are, कुछ आदमी ऐसे होते हैं, मर्द ऐसे होते हैं, they feel that they are trapped in a man's body. There actually should be a woman, and vice versa. कुछ women ऐसी होती हैं, they feel that they are trapped in a man's body. This is not a mental illness as per Mental Health Act. Transvestism, कुछ लोग ऐसे होते हैं, they like to cross dress, some men like to wear women's clothes and vice versa. That is not a mental abnormality or mental illness. And very, very important, the issue of dependence on and use of alcohol and drugs. So कोई शख्स अगर intoxicated है at the time of the offense, for example, Ali, remember Ali's case. Ali was heavily involved in the drug scene and alcohol scene. So at the time of murdering his mother, if he was intoxicated with alcohol or cannabis, charas ya ganja, whatever, that does not automatically means that he was unwell and he was legally insane, because dependence on and use of alcohol or drugs is an exclusion criteria as per Mental Health Act of Punjab, Sindh, Balochistan and KPK. Having said that, and Robin Maher will perhaps would like to say a word or two here. Having said that, sometimes the relationship between the offense and the use of drugs and alcohol is not that straightforward. So sometimes what happens is that I drink alcohol or I smoke cannabis and I start getting these bizarre ideas that my mother is an evil person and God is asking me to kill her, and I kill her. And then the psychiatrist would tell the court, well, that person suffered what we call the drug-induced psychosis. So drug or alcohol ने जो था उसका psychosis जो है वो induce कर दिया, जिसकी वजह से उसने ये act commit किया है. अगर सिर्फ इतनी सी बात है तो मेंटल डिसऑर्डर जो है वो एंगेज नहीं होगा, क्योंकि ड्रग और अल्कोहल जो है दे वर द प्राइम फैक्टर इन मेकिंग दैट पर्सन कमिटिंग दैट दैट एक्ट. वो बंदा जब सोबर हो जाएगा, अल्कोहल और कैनबिस के इफेक्ट उसके जिस्म से निकल जाएंगे, ही विल बी कंप्लीटली सेन and then he'll be responsible for what he did because he consciously, involuntarily decided to consume alcohol or smoke cannabis, and as a result he became paranoid and murdered his mother. So this is one possibility. The other possibility is that Ali had some mental health problems already थोड़ा सा पैरानोया भी उसको चल रहा था, वो सोशली भी आइसोलेट हो रहा था, एंड देन ही स्टार्टेड टू स्मोक कैनबिस और ड्रिंक अल्कोहल, एंड देन हिज पैरानोया बिकेम profound or severe, and then he killed his mother. So that, what we say, is the drug or alcohol precipitated psychosis or precipitated paranoia. There lies a defense of insanity. क्योंकि यहाँ पर जो है ड्रग या अल्कोहल ने जो है उसकी ऑलरेडी एग्जिस्टिंग इलनेस को एक्सासरबेट कर दिया और इतना ज्यादा बढ़ा दिया जिसकी वजह से वो कॉन्शियस कंट्रोल खो गया एंड ही कमिटेड द एक्ट. तीसरी जो इवेंचुअलिटी है वो ये है कि जो ना ड्रग प्रेसिपिटेटेड साइकोसिस है, ना ड्रग इंड्यूस साइकोसिस है, लेकिन कुछ इस तरह के इश्यूज हैं उस बंदे की अपब्रिंगिंग में और बैकग्राउंड में जिसकी वजह से उसने अपने जहनी केओस और जहनी जो सारी ट्रबल है उससे कोप करने के लिए ड्रग्स और अल्कोहल को इस्तेमाल करना शुरू किया. फॉर एग्जांपल एंजाइटी से कोप करने के लिए, फॉर एग्जांपल कहीं बुली हो रहा था उससे कोप करने के लिए, फॉर एग्जांपल उसकी वाइफ के साथ झगड़े, बच्चों के मसले, व्हाटएवर, he decided to use that in order to cope with the issues going on in his life, and as a result he acted in an unlawful manner. Then his lawyer can use those issues as mitigating factors. So it's not just that issue is all about insanity and not insanity. It is also about mitigation. So you understand that it's not that straightforward, the issue of intoxication with alcohol. And finally, I think I'll just finish off here and open the forum for discussion. And before I open the forum for discussion, I want to tell you this, that with the help of Pakistan Psychiatric Society and especially a few people I want to mention here, Professor Iqbal Afridi, Dr. Faria Iqbal, Dr. Muzammil Haider, and Ms. Zainab, जो कि लॉयर हैं, उनकी मदद से जो है हमने ये मेंटल हेल्थ एक्ट जो पाकिस्तान का है मुख्तलिफ प्रोविंसेस का, उसको पढ़ा, उसको डायसेक्ट किया और उसकी एक सिंपल प्रेजेंटेशन इस तरह की बनाई जो कि साइकाट्रिस्ट, लॉयर्स और क्रिमिनल जस्टिस प्रोफेशनल्स को इन्फॉर्म कर सके कि इसके अंडरलाइंग प्रिंसिपल्स क्या हैं और इसको किस तरीके से काम करना चाहिए लोगों के राइट्स को डिफेंड और सेफ गार्ड करने के लिए, वो लोग जिनके साथ मेंटल हेल्थ प्रॉब्लम्स भी हैं, उनसे क्राइम भी कमिट हो गए हैं. तो इस सिलसिले में हमने जो है 2019 में ये प्रोग्राम को डेवलप किया. इसको जो है हमने 2 दिन का प्रोग्राम जो है कराची में पहले इसको कंडक्ट किया, उसके बाद जनवरी दिस ईयर हमने रावलपिंडी में कंडक्ट किया. हमारा ये प्रोग्राम था कि इसको इस समर में जो है इस्लामाबाद और लाहौर में दोबारा करना था, लेकिन कोविड की वजह से हम नहीं कर सके. सो ये वेबिनार्स को हम जो है वो अरेंज कर रहे हैं और नेक्स्ट वेबिनार जो है वो मेंटल हेल्थ एक्ट के बारे में होगा. सो दिस इज द प्रोग्रेस सो फार, एंड I wanted to say that the next step is the meaningful embedding of this mental health act. I don't think we can do it on our own. I firmly, wholeheartedly believe that it will be the legal fraternity, the active and the respected legal fraternity of Pakistan, which will help us psychiatrists to embed it and to implement it, because this is what I've seen in this country. This is what I've seen here where I work in Scotland in the last 20 years, कि यहाँ की जो judiciary है, यहाँ के जो lawyers हैं, उन्होंने हमारी help की इसको implement करने में. So मेरी आपसे ये इल्तिजा है और मेरी आपसे ये plea है, help us to implement it, because that is the only way for us to work together to safeguard the rights of mentally disordered people. तो यहाँ पे मैं थोड़ा सा फिनिश करता हूँ और मुझे पता है काफी लोगों के बहुत सारे क्वेश्चंस हैं और रेज हैंड्स हैं. I would love to hear from you and interact with you. Please go ahead. The forum is yours now. Thank you.
So before we go ahead, we would like to invite Professor Muhammad Iqbal Afridi.
मैं सोच रहा था कि आफरीदी साहब से जो है बिल्कुल लास्ट में जो है वो स्पीच लेंगे एक, बिकॉज उनके लिए मेरे पास भी कुछ क्वेश्चंस हैं, आज उनको इतना हल्का नहीं छोड़ना है. Afri Saab, be prepared. I've got some questions for you as well today because I'm in the presence of the judges of Pakistan. So I will take the full liberty of challenging you today. तो लेकिन दो और participants हैं जिन्होंने raise hand किए हैं. आफिया, फारिया, उनको please judges जो हैं हमारे
Amjad Nazir साहब, you can talk now.
जी. जी अमजद साहब, please go ahead.
Amjad Saab, are you there with us?
और किसी को ले लीजिए अगर अभी अमजद साहब अनम्यूट नहीं हो पा रहे हैं तो. एक और साहब ने भी किया था, कोई और जज साहब भी थे. जी. ओके आफिरी साहब प्लीज. अच्छा, अमजद नजीर साहब ने दोबारा रेज हैंड किया है. अमजद साहब प्लीज बोलिए.
Sir, I think he's not there. That is Professor Iqbal Afridi who has raised
Okay, Afridi साहब प्लीज बात कीजिए. Go ahead.
Can you hear me?
जी.
Bismillahirrahmanirrahim. First of all, I am very thankful to all of you, especially our worthy judges and lawyers and all the participants, even psychiatrists. And I'm especially thankful to Dr. Khurram Khan and Ms. Robin Meher for sparing their time. And I think that such webinar will have enormous impact on the law and psychiatry in Pakistan, because we are at the development stage with forensic, proper trained forensic psychiatric is not there. So we have started this program, and on behalf of the Pakistan Psychiatric Society, I'm very thankful to all of you. बस यहाँ पे इस मौके से फायदा उठाते हुए, जैसे खुर्रम खान साहब ने कहा कि हमारे वर्दी जजेस भी हैं, लॉयर्स भी हैं. 2001 में ये एक्ट बना, उसके बाद में तकरीबन 20 साल हो गए, और 2013 में सिंध ने बड़ी लीड ली और यहाँ पे शुरू किया गया सिंध मेंटल हेल्थ एक्ट. जब वो 18वीं तरमीम की रोशनी में ये हेल्थ का जो सिस्टम था वापस चला गया, अब दोबारा वापस फेडरल में चला गया. तो हमें जो चैलेंजेस हैं, नंबर 1, एक तो सबसे गिलगित बल्तिस्तान का में वहाँ और आज़ाद कश्मीर में जो है उसका भी हमें जिक्र करना चाहिए. तो हमें चैलेंजेस थी, जो सबसे बड़ी चैलेंज थी कि इम्प्लीमेंटेशन कैसे हो. इम्प्लीमेंटेशन के लिए अथॉरिटीज थी. उस सिलसिले में पाकिस्तान साइकेट्रिक सोसाइटी के सदर के, जिससे मैंने चारों सूबों के उनको लिखा चीफ मिनिस्टर्स को कि भाई अथॉरिटीज तो बनाएं, वो तो बना दी, लेकिन इसके साथ में थोड़ा सा बजट भी रखें कि वो कैसे जो है ट्रेनिंग कराएंगे, किस तरह से बोर्ड बनेंगे, किस तरीके से जो है अप्रूव्ड साइकेट्रिस्ट बनेंगे. अब तो उसका जब कुछ जवाब नहीं आया, किसी एक भी चीफ मिनिस्टर ने जवाब नहीं दिया. तो मैं समझता हूँ कि यहाँ पे हमारे वर्दी जजेस हैं जो कि पाकिस्तान की कई चीजों को उन्होंने ठीक किया, और साथ में लॉयर्स ने, कि इनको पुश करें कि भाई अथॉरिटीज तो मुश्किल से बना ली. और सिंध की अथॉरिटी हमने कैसे बनाई मैं बता नहीं सकता, कि हमने 13 नाम दिए कि इसमें से 6 ले लो, 13 के 13 अनाउंस कर दिए थे. लेकिन खुशकिस्मती से सिंध अभी भी आगे है, और उसमें हमारे डॉक्टर करीम ख्वाजा जो चेयरमैन है, उसकी तवज्जो से 10 करोड़ रुपए जो है वो हमें उन्होंने दिए, जिसपे हमने ये प्रोग्राम स्टार्ट किए थे. और अभी उसमें जो है 2 दिन पहले उसका वेबसाइट शुरू किया कि आ गई हो. तो जब लोगों को आ गई होगी, जो स्टेक होल्डर लॉयर्स हैं, जजेस हैं, साइकेट्रिस्ट हैं और कॉमन मैन है, उसके बाद अगला हमारा स्टेप है कि इसको जो है खासतौर पर सहाफियों और आम लोगों तक कैसे पहुंचे कि वो अपने राइट्स का पता हो. तो मैं समझता हूं कि यहाँ जिम्मेदारी, बल्कि हम रिक्वेस्ट करते हैं, ये हाथ जोड़ के करते हैं कि अब ये गवर्नमेंट अगर नहीं कर रही है तो अब ये जजेस और लॉयर इस बात को उठाएं कि भाई कम से कम अगर नहीं इसकी लिए थोड़ी सी बजट रखें. अगर पूरे सूबे में नहीं कर सकते, जैसे मिसाल सिंध के अंदर 18 जिलों में साइकियाट्रिस्ट ही नहीं है, तो हम इसी तरह से कहते हैं जब ट्रेन जजेस और लायर ना हो, कम से कम एक डिवीजन लेवल पे तो एक जज हो जो कि इस एक्ट को समझे, और उसके अलावा जो पाकिस्तान पीनल कोड और इसके दरमियान जो तफर्रुक है या फर्क है उसको समझे। जैसे कि सेक्शन 49 जो है इस एक्ट का, वो सुसाइड को समझ रहा है कि इसकी हेल्प की जरूरत है, उसको इलाज की जरूरत है, जबकि 225 और पाकिस्तान पीनल कोड कहता है कि नहीं, ये अगर बच गया और उसने अटेम्प्ट किया उसको सजा देनी चाहिए। तो ये हमने जो है इसके लिए भी जो है असेंबली तक जो है वो सेनेट में चीज करवा दी थी, फिर कौमी असेंबली इस दौरान में डिसॉल्व हो गई, नहीं हो सका। ये भी जो है डिस्पैरिटी को रिमूव करना है। तो मैं समझता हूँ कि आप लोग जो उन्होंने आज इसमें पार्टिसिपेट किया, इसका बड़ा इम्पैक्ट होगा, और आप लोगों की तवसत से जो है अगर ये अथॉरिटीज एक्टिव हो जाएं और उसके बाद में जो है बोर्ड बने और अप्रूव्ड साइकियाट्रिस्ट के लिए ट्रेनिंग के लिए हमने खुर्रम खान साहब से, और इधर मैं ये भी बताता चलूं कि यहाँ तारिक साहब हैं जो कि कनाडा में, इनकी तवज्जो से हम ट्रेनिंग का प्रोग्राम शुरू कर देते हैं। जो अप्रूव्ड कम से कम 2 दिन की ट्रेनिंग जो की हो तो उसका थोड़ा बहुत पता उसको अप्रूव्ड साइकियाट्रिस्ट करार देते हैं, और फिर जो है जो मेंटल हेल्थ अथॉरिटीज है उसके लिए थोड़ी बजटिंग हो। किसी भी सिर्फ सिंध के अलावा बाकी किसी अथॉरिटी ने मीटिंग ही नहीं की, और 20 साल हो गए इसको, और हमने हर चीफ मिनिस्टर को लेटर लिखा, किसी ने जवाब नहीं दिया। बहुत शुक्रिया आप सबकी। खासतौर पर मैं चुगताई साहबा का भी शुक्रगुजार हूँ कि उन्होंने जो है इस चीज में प्रोग्राम को ऑर्गेनाइज करने में हेल्प की। थैंक यू वेरी मच वंस अगेन।
थैंक यू आफिदी साहब। So Huma and Faria, I'm really interested to hear from our judges. Please, if there are any comments, any questions, this is an opportunity for me to learn as well. So please go ahead.
Sir, there is one comment that mental health ordinance is not applicable in Gilgit-Baltistan that Dr. Iqbal Afidi just mentioned right now.
Okay. मुमताज ने अपना रेज किया है हैंड्स। मुमताज आईफोन। यस सर।
अच्छा, मैं यहाँ ये भी बताता चलूं कि हमने तो 2 लोग, जो डॉक्टर फारिया जो कि क्वालिफाइड साइकियाट्रिस्ट थे, और डॉक्टर मुजम्मिल को आप इंस्पायर किया कि चलें ये जो मेंटल हेल्थ वो है एक्ट है, इस पे उबूर हासिल करें, इसको हेल्प करें, इसको समझें। और हम तो चाह रहे हैं कि इन दोनों जो हैं फॉरेंसिक साइकियाट्रिस्ट बने कि मुल्क की जो कमी है पूरी हो जाए।
इंशाल्लाह इंशाल्लाह।
I to say Mumtaz here. I want to say that mental health ordinance is not applicable in Gilgit-Baltistan. In such situation, what to do there?
ये मैं रिस्पॉन्ड करता हूँ मुमताज आपको।
जी सर।
आपकी सीआरपीसी में जो प्रोविजन है वो भी काफी है।
वो है सर, लेकिन ये जो मेंटल हेल्थ ऑर्डिनेंस में जहाँ रिक्वायरमेंट है,
तो वेलफेयर के लिए है, और वो आपका चूंकि इंडिपेंडेंट एरिया है तो उसके लिए तो लेजिस्लेशन।
जुडिशियल एकेडमी कैन रेज दिस क्वेश्चन एज वेल एज पहले सर वो होता था, क्या नाम है, सुप्रीम कोर्ट में, वहाँ हमने अक्सर बहुत सारे ऐसे लॉज थे जो एप्लीकेबल नहीं थे, वी हैव रेज देयर, और उन्होंने उनको कहा कि जीबी गवर्नमेंट को, क्योंकि these laws are applicable through federal government.
I will talk to your chief court, and you got a very dynamic registrar there and very dynamic chief judge. So I hope they will work for that, और वो extend करवा देंगे, या आपके लिए अगर नई legislation की जरूरत हुई तो वो करवा देंगे।
Simply there need to be extended, sir, nothing to be else.
वही वो जो भी है वो कर लेंगे, जो needful है they will do it, they will do the need.
Thank you sir, I am highly obliged.
जी मुमताज साहब, thank you for your question, and डीजी साहब thank you for your answer. मैं सिर्फ ये कहना चाहता था कि ये आपको पता है कि चारों प्रोविंसेस में जो है वो मेंटल हेल्थ एक्ट है, मेंटल हेल्थ ऑर्डिनेंस तो अब है ही नहीं। मेंटल हेल्थ एक्ट ऑर्डिनेंस 2001
Sorry, that is act, sir.
Sorry,
that is act. Yes, mental health ordinance.
जी जरूर, yes sir. So मैं सिर्फ ये बोलना चाहता था। Thank you.
इस्लामाबाद में अभी भी ऑर्डिनेंस है, कैपिटल।
अच्छा, ये मुझे नहीं पता था।
Is there, so that ordinance can be extended to Gilgit. There's no issue.
I see. Okay, thank you.
Thank you.
At the end, Dr. Khurram, I'm very grateful to you. बहुत आपका शुक्रिया, आपने टाइम दिया, एंड मुझे जो फीडबैक कॉन्स्टेंटली आ रहा है वो यही है कि वेरी इंफॉर्मेटिव, वेरी यूजफुल, और ऑफ कोर्स ये एक अछूता मौजू है और इंतहाई अहम मौजू है हमारे यहाँ, और एक इग्नोर्ड और मार्जिनलाइज्ड एरिया है जहाँ लोगों को समझने की वाकई ज़रूरत है। तो हम आपके भी मशकूर हैं, रॉबिन के भी मशकूर हैं, उन्होंने अपना टाइम दिया, और मैं तमाम पार्टिसिपेंट्स का भी इंतहा मशकूर हूँ। हमारे डिस्ट्रिक्ट जजेस साहिबान, इनमें से अक्सर लोग छुट्टियों पर हैं, उन्होंने छुट्टियों में अपना वक्त दिया और सीखने की कोशिश की, और जो लोग ड्यूटी पर हैं उन्होंने अपनी ड्यूटी के टाइम के बाद भी वो बैठे हुए हैं, एंड दे हैव बीन लिसनिंग एंड हियरिंग टू दी, आपकी इस टॉक को वो सुनते रहें। सो मैं उनका, और बड़ी पेशेंटली सुनते रहें, बड़े डिसिप्लिन्ड तरीके से सुनते रहें। सो वी आर इनकरेज सर, मैं आप सबका बहुत मशकूर हूँ, और अल्लाह करे हमें अल्लाह और ऐसे मौके दे और हम आपके साथ इंटरेक्ट करते रहें। सो थैंक यू ऑल।
Thank you very much.